Well, there's been a lot going on in State Parliament this week, with the ICAC bill getting the go-ahead and a historic change to the criminal appeal process being introduced. This program has pushed both reforms for many years now, but the breakthrough in the appeal procedures would not have made it this far without the efforts of independent MLC and Bressington. Here's Graham Archer with a quick look at what's been achieved.
Would you describe this as a historic moment?
Oh, absolutely it is. You know, rarely do we get time in Parliament or a time in Parliament that we can actually celebrate a reform to the justice system that's going to impact on people's lives in a positive way, and this is one of them.
It's a breakthrough that many have worked years to bring about.
This bill is intended to improve the present procedure for appeals in South Australia. There has been some agitation in South Australia for a process to enable renewed appeals against conviction on the basis of fresh evidence.
Today, the Attorney-General John Rao introduced a bill into Parliament which will fundamentally change the criminal appeals process and mean those suffering from wrongful convictions can have their cases reopened by a court rather than the archaic and flawed last resort of petitioning the Governor.
Because the process up to now has been a political one rather than a legal one, surely.
Well, that's exactly right.
And from being the least likely place to change our justice system for the better, if passed, this will make SA a national leader.
This reform is about setting a terrible injustice that's existed for a very, very long time. It's probably the first step now in setting that right and making sure that it is a justice system, not just a law and order system.
And there are many who've had a role to play in this historic change.
I'm nearly jumping out of my skin.
Independent MLC Anne Bressington has been on it for 5 years and brought the matter to a head by establishing a select committee to consider how best to deal with cases where the processes had failed or new evidence had come to light after normal appeals had been exhausted.
There were so many submissions received that the government could no longer ignore the fact that this was something that needed to be dealt with.
Dr Bob Moles, academic lawyer and author, first raised the idea of a commission to look into such cases as it exists in England. That idea had some very heavyweight support.
The High Court won't receive new evidence, however compelling it may be, and that is, I think, a weakness in our appeal system in Australia, that we can't, in the final court, receive fresh evidence where, for example, it is it's compelling and it shows that the person is actually innocent.
The committee took up the issue and recommended a simple but effective solution.
The most simple of tweaks to the law fixes this now, and that's basically what amazed me with this, that it would be so simple.
And if the Parliament agrees the bill is broad enough to deal with tainted evidence as well as fresh evidence, then the law will come into effect next year.
I'm hopeful that by June of next year, this bill will be it will be there and working.
The AG is even more optimistic than that.
We could be looking at February.
February? Next year?
Yes.
Well, that's reason for optimism.
Yes, yes.
We need to be aware that while we have innocent people in jail, the real criminals, the real murderers, the real rapists are still out there doing what they do. So until that's righted, we don't have a justice system and people can't actually feel safe.